Welcome, welcome. This is the Lincoln Lawyer. Nice to see you again. Today we're going to cap off our marital property circle of death with common law marriage. So I'm going to get into the 12 states that recognize common law marriage, then how they define common law marriage, and what you need to do to prepare yourself. Very simple, brief video. I hope you find it informative, and I do hope my ceremonic battery holds. So what are the 12 states that recognize common law marriage? Write us down. So Alabama, Colorado, District of Columbia, Iowa, Kansas, Montana, New Hampshire, Oklahoma, Rhode Island, South Carolina, Texas, and Utah. If you live in any of those states and you reside with a partner without being married, you are running the risk of being deemed to be married. So how do they define marriage, generally speaking? Alright, so there's no specifics. Each state is different, and each court, each judge is different. So first of all, you need to reside together, obviously. You do need to live together for an undetermined period of time. It's not clear. I would say pretty much anything a year plus would be enough. So number two, you have to hold yourself out to the public as being married. This means you have to tell people that you are married. Tell your family, tell your friends, wear wedding rings, have life insurance policies on each other's life, be on the lease together, buy property together. So pretty much anything that tells the world that you are married, okay? Having a dog is not enough. So number three is going to be intent. So intent is reading a person's mind. Basically, this is done by looking at the factors under number two. It would include the similar factors such as holding yourself out, being on utility bills together, buying stuff together, having a single bank account. Pretty much everything that's listed under number two will be considered as evidence of marriage. And if you are deemed to be married, then obviously you'll have to go through a formal divorce, a formal division of property and assets, and so all that pain in the ass that comes with it. Very basic. So what do you do? How do you prepare for it? Well, very simple. You need a cohabitation agreement or a residence sharing agreement. Not too complicated. This is just like a prenup, except this expressly says that there will not be any common law marriage deemed to occur in your cohabitation of a single residence. Also, additionally and importantly, it's going to separate all property. It will prevent the creation of any marital estate for any court or judge to decide the division of as they deem fit. Whatever you bring and purchase during the marriage, and whatever the other person brings and purchases during the marriage remains their separate property. What this means also is if you purchase assets together, you need to document this stuff. You need to have the receipt, you need to have bank account statements which show the money leaving each account and the proportion of ownership, because the agreement will state that upon dissolution of the relationship, which will never become marriage, then assets commingled, assets bought together with each other's money will be either sold off or will be bought out by the other party, will be exchanged. You pretty much do whatever you want, but you do need to document the proportion of ownership of each party of each specific asset. I'm not saying how much the asset should be valued. Probably, it depends on your financial status. Anything over 500, 1,000, 5,000, something like that. Okay, so I hope this has been informative. I'm going to cut it off right here. Let me know if you have any questions. Like, subscribe, be cool, and stay out of court.